Hello and welcome to SEO Daily. Today we'll be breaking down day 12 of arguments in the challenge to the abrogation of Article 370. On day 12, Solicitor General Tushar Mehta completed arguments in favor of the abrogation. Mehta began his arguments by responding to the petitioner's argument that the abrogation of Article 370 broke a constitutional promise made to the people of Kashmir. He argued that the provision put the people of Jammu and Kashmir on a different footing than the rest of the country and that the President had the power to remove such a provision. Chief Justice D.Y. Chandrachud, however, pointed out that the issue with regard to Article 370 was that the Union used Article 367, an interpretation clause, to alter the meaning of the Constituent Assembly to mean Legislative Assembly, and in turn used this to abrogate Article 370. Standing firm, Mehta responded that the President had the power to use Article 367 because after 1957, the Constituent Assembly of Jammu and Kashmir had dissolved. If it was accepted that Article 370 could not be abrogated at all, then it would mean that Article 370 was a permanent provision, which he argued it was not. He then argued that by not choosing to abrogate Article 370 when it dissolved, the Constituent Assembly left absolute discretion to the President. The requirement under Article 373 to get recommendation of the Constituent Assembly was only just a recommendation. The President was never bound by it, he said. The Union could have abrogated the provision without the limitations of the provision. Instead, he said, considering the strategic nature of the state, the Union wanted to democratize the process of repealing the provision and chose to introduce it in both houses of Parliament. Justice B.R. Gawai brought Mehta's attention to the language of the proviso to Article 373. This suggests that the recommendation is mandatory for abrogation. Mehta stated that the purpose of adding the word recommendation was to give an option to the Constituent Assembly during its time to make recommendations and did not apply after the body dissolved. He argued that the President's power could not be dependent on decisions made by a different body. CJI Chandrachud stated that Mehta's submissions may not be correct, with Justice Sanjeev Khanna adding that the Constitution is a supreme document which often places restrictions on the judiciary, the executive, and the legislature. The Chief Justice stated that the word shall is a clear indication that there has to be a recommendation. Mehta requested the court to interpret this to mean that the recommendation may be mandatory, but the President was not bound by it. Mehta reiterated his arguments from day 11 on how the Constituent Assembly was merely the name of a body that was effectively functioning as a lawmaking body. The Jammu and Kashmir Constitution, Mehta stated, had none of the attributes of a constitution and was simply a piece of law which was known as the Constitution until the abrogation. He said that the preamble of the Jammu and Kashmir Constitution does not say that the Constitution is being created for the governance of Jammu and Kashmir, but instead says that the Constitution is there to further define the existing relationship of the state with the Union of India as an integral part thereof. CJI Chandrachud added that the provisions of the Jammu and Kashmir Constitution made it obvious that the Jammu and Kashmir Constitution was meant to be subservient to India. Mehta asserted that Article 370 was always meant to be temporary for many reasons. Firstly, the Constitution framers inserted the provision under Part 21 of the Constitution, which consisted of temporary, transitional, and special provisions. Secondly, the powers accorded to the President as well as the state government under Article 370 were expansive and extremely wide. Therefore, bearing in mind the expansive powers, the framers would surely never have contemplated this provision to remain forever. Next, the Article 370, he said, deprived the people of Jammu and Kashmir and Ladakh of being treated at par with the citizens with the rest of the country, which is a suggestive indication that the framers never wanted the provision to be permanent. Moreover, Article 370 was the only provision which had a self-destructive provision under Article 373. Lastly, Mehta argued that Jammu and Kashmir was one-of-a-kind state because of its strategic border, strategic location, border state, history of terrorism, history of infiltration, history of influence from outside forces. He argued that the reorganization of states was done with the blueprint of what the Union would do post-reorganization. This plan included issues such as gainful employment of the youth in the mainstream, schemes for the protection of border residents from shelling, and the starting of a democratic self-government. This was the breakdown of day 12 of arguments in the Article 370 case. Make sure to visit scobserver.in to read the full report of the day and much more on the activities of the Supreme Court. Thank you for watching.